Good evening, everyone, and thank you for being here. My name is Beth Hendricks. I'm the Executive Director of the League of Women Voters of Colorado, and we are excited to present the second session in our activism training series. I hope you all know that for 106 years, the League of Women Voters has been marching and advocating and fighting for equality and equity, inclusion and justice for all people here in the United States. And we intend to do this for another 106 years, if not longer. And we need your help. We need your support in doing that. So thank you for being here. The next in our series will be on the 1st of April, Activism Beyond the March, other peaceful ways to resist. We'll talk about economic boycotts and divestments, various kinds of legislative or of advocacy, and a lot more. On the 15th, we'll talk about reaching marginalized voters. Our partners from Mi Familia Vota and Colorado Criminal Justice Reform Coalition will discuss outreach to Spanish-speaking and incarcerated voters. On the 29th, we'll talk about holding local government accountable through League foundational programs of Observer Corps and Eyewitness. On May 6th, we will discuss the power of conversation. The power of conversation to de-escalate, connect, and promote a healthy American democracy. The presenter will be Martine Carcason from Colorado State University Center for Public Deliberation. And the final one on May 20th is the Colorado Budget Process 101 with our friends from the Colorado Fiscal Institute. It's hard to advocate here in Colorado if you don't know how our budget works and is formed. So I hope to see you at each one of these. And we appreciate your motivation in ensuring that Colorado remains the best place to live. Now, I am very pleased to welcome Christian Gardner-Wood. He's a Chief Deputy District Attorney for the 20th Judicial District, Boulder County, District Attorney's Office in Colorado. He graduated from the University of Colorado Law School in 2007 and has been a prosecutor in Colorado for 18 years. He currently oversees the Community Protection Division and the Center for Prevention and Restorative Justice for the 20th Judicial District. I'm a big fan of restorative justice. In these roles, he coordinates outreach, legislation, and policy initiatives, and supervises the Diversion and Restorative Justice Unit. He also continues to prosecute serious felony cases such as homicides, sexual assaults, and physical assaults. Most of his career has been dedicated to prosecuting offenses involving vulnerable victims, including children, elders, sexual assault victims, and human trafficking victims. He regularly trains in the areas of human trafficking, child abuse, sexual assault, prosecution skills, juvenile justice, financial exploitation, elder abuse, mandatory reporting, criminal justice reform and equity, and diversion and restorative justice. And now you can add activism training and safety as well, Christian. We really appreciate your being here. Welcome.
Thank you so much for that introduction, Beth. I really appreciate it. It's great to be here, and I'm excited to add training on activism to the list of presentations that I give. I'm just going to share my screen here. Give me one second.
And folks, we think it would be best if we held questions until the end of Christian's presentation. Feel free to put them in chat as you're thinking them so you don't lose them. And we'll bring them up at the end. And Christian, it's all you.
Perfect. Thank you so much. Again, appreciate the introduction and the opportunity to be here. My boss, our elected DA in Boulder County, Michael Doherty, was hoping to be here. He and I have done a lot of work together on Know Your Rights trainings and immigrant protection and immigrant outreach. But unfortunately, his schedule didn't allow. So I'm excited that I'm able to be here with you all this evening. Um, I Just a quick disclaimer, I'm a lawyer, but I'm certainly no First Amendment expert and don't litigate in that area. I've spent my entire career coming up on 19 years as a prosecutor. So really, this is designed as a generalized framework for knowing your rights as it relates to First Amendment and protesting in Colorado. It'll certainly touch on what the laws in Colorado talk about, what the constitutional protections are, but certainly, just provide it as overall information. And then I'm happy to answer questions as best as I'm able towards the end of the session today. I'm looking forward to the questions. I want to make this useful and relevant to you all. So the way I've designed the presentation is really just to hit some high-level areas within this idea of know your rights, and then welcome an engaging question and answer session towards the end. Obviously, you all are on a activism training, so I probably don't need to tell you this, but it's really important, and I'm very happy that the League of Women Voters of Colorado is holding this training series and specifically inviting me to talk to you all this evening. It's important when we think about protesting that why that matters is strengthening public engagement, public empowerment, making sure that Coloradans know how they can speak up and how they can speak out as community members, and provide a level of guidance to community members that do want to engage in that activism, but make sure that people are doing it in a safe and informed way as best we can, and protecting themselves as they're doing it. I will start just a little bit that the reason that I think Beth had reached out to my office to do this presentation is Michael Doherty's been doing Know Your Rights presentations as it relates to immigrant rights and immigrant protection across the state of Colorado, because it's so important, particularly right now with what we see with the federal administration, what is happening with ICE and border protection. And so this is something that we've engaged in as an office for many years, but obviously has become extraordinarily relevant within the last year with what we see happening with the federal government. So while I'm going to spend most of our session this evening talking about specific protester rights, I did want to set the framework that this was really an outgrowth of the work that Michael Doherty has been doing, particularly within the area of immigration. With that in mind, I did want to provide some background information about what our office has been doing here in Boulder County. A number of years ago, we implemented an immigrant collateral consequences policy, essentially recognizing that somebody that comes through the criminal justice system, if they are an immigrant in the United States, there will be additional consequences for them. And it used to be years ago, prosecutors would say, well, that's collateral, that's separate from the criminal justice system. That's not for us to decide or us to take into consideration. Frankly, Michael and I believe that was a short-sighted view, because if somebody, gets a probationary sentence for a low-level violation, we know that there's going to be low-level consequences. But if that results in removal from the country, that's no longer a low-level consequence, and it's not collateral to the criminal justice system. That then really overtakes the criminal justice system. So we implemented a policy which we updated last year in terms of how our office at the Boulder DA's office deals with that and should be considering that. We've also engaged in a number of immigrant protection initiatives, including I Certify All You visas, in Boulder County for people that are victims of crime that are looking for immigration status and protection based on their status of being a victim of a crime in Colorado. We also work very closely with some of our allies in the immigrant rights organizations. And then in the last year, again, I mentioned that this has been a major issue for all of us over the last year with what we've seen. So we put together some information about immigrant rights, specifically within the Boulder County justice system, as well as an overall Know Your Rights flyer and bulletin that we've made available, as well as have on our website. And I have that link for you there if any of you are interested. And this is really kind of what that looks like, really talking at a high level standpoint about Colorado agencies not being able to obtain or provide immigration information. So not asking somebody for that before providing services or while providing services to individuals in our community. And to the extent that that information is obtained, not sharing that with other individuals. Not allowing for arrests in certain protected spaces. There used to be a federal protected spaces doctrine that has since been revoked by the federal government. So Colorado has implemented laws to have certain protected spaces, like not allowing for arrests in courthouses or in public areas of hospitals or in non-public areas of hospitals, schools, et cetera. Not honoring civil immigration detainers, essentially non-warrants, things that are not signed by federal judges, and just outlining general constitutional protections, which is what we're going to spend most of our time this evening talking about, and clarifying that in Boulder County, that in all circumstances, there will be a full and fair investigation of any criminal activity that occurs, including if that criminal activity is done by federal agents that come into our jurisdiction. So I certainly welcome you to check out our website. All that information and more is there if you're interested in that. I'm also happy to talk about that if you all are interested during the question and answer session. But let's really dive into protester rights in the state of Colorado and obviously by association in the United States. Really, we're grounded within the First Amendment of the United States Constitution and the freedom of speech, assembly, and right to petition the government to redress grievances. Obviously, within that, individuals always have a right to express their views in public spaces. The government cannot choose what messages are put out. They can't punish for that message, even if that message is controversial or offensive. Similarly, within that First Amendment right is the freedom of assembly, the right to gather peacefully with others to protest or simply to gather in public spaces, sidewalks, parks, plazas, again, without government interference with that. And then part of that freedom to petition for redress of grievances is also the right to advocate for policy change. That's through marches, rallies, protests, demonstrations, contacting your local elected officials, et cetera. Additionally, here in the state of Colorado, our Colorado Constitution independently protects free speech and assembly. And in fact, in some cases, has been interpreted by Colorado courts to provide broader protections than the United States Constitution. So while it's very similar, the language is slightly different in the Colorado Constitution. And because of that, Colorado courts have granted additional protections that they see that exist within the Colorado Constitution that may not have been implied in the federal Constitution by federal courts. An example of that there was a case a number of years ago about assembly and protest and speech at a public mall. That's something that the federal Constitution and the way it's been interpreted, it's not a government facility, and the government wasn't going to impose First Amendment rights within that, even though it may have been a public gathering spot. It wasn't something that the government controlled. The Colorado Supreme Court has determined that because that is a public space for public gathering, that there are some rights to protest and assemble in some public spaces, publicly available spaces like that. There can still certainly be regulations, and everything becomes very fact specific, but that's one example of where Colorado protections have been interpreted to be somewhat broader than the US Constitution. What we know is that the United States Constitution essentially presents a floor for rights, the minimum rights that need to be provided within the United States. Individual states can expand upon those rights, and this is an area where Colorado has done so through our Constitution. So what does that mean as it relates to your rights as a protester? Well, there's certainly still certain things that a protester can and cannot do. A protester certainly can protest in public spaces, be it parks, plazas, sidewalks, recognizing, though, that there are and can be at times permitting requirements for large events, particularly if we're talking about large events that may obstruct access to those parks, those sidewalks, those city streets. That is something where a permit may need to be required. All citizens, all protesters can, and I shouldn't say citizens, I use that term very broadly, but I also catch myself on a pretty regular basis nowadays that I think of that term very broadly, but I recognize we're not in an environment where that term is nearly as broad as it should be. So I don't mean citizens in the legal context. I mean individuals. When I say that, the individuals can photograph and record police officers performing their duties in public. This is something that has been clarified by courts and been clarified in Colorado law. As part of protesting, people certainly can carry signs, they can chant, they can hand out literature expressing their views. Individuals have a right to refuse, of course, answering police questions beyond identifying themselves. Individuals do have to identify themselves if lawfully approached by law enforcement, but beyond that, people have a right to remain silent. With photograph and recording anything in public spaces, individuals have a right to observe and document police activity from a safe, albeit non-obstructive distance. And we'll talk more about what that means in a little bit, but certainly to the extent that individuals are engaged with law enforcement or recording law enforcement activity, documenting that activity, they can't get to the point where they are physically obstructing law enforcement's ability to do their job, but certainly they can document what law enforcement is doing, whether that be photographs, videos, or otherwise. And of course, individuals can counter protest. That is whether we are the counter protesters or we are engaged in some activity, some protest, and there are other counter protests and protesters that are part of that. They have these exact same rights. And in fact, a lot of times there are individuals that choose to essentially be obstructionists, be there solely to counter protest, solely to try and incite things, to make things more difficult for the original protesters. They still have that right. To the extent that becomes a problem and there is concern for safety or a concern about keeping the peace, law enforcement does have the right and ability to separate the groups that may be protesting and counter-protesting. Similarly, when we think about some of those rights and what I indicated a protester can do, there's certain things that cannot be done. A protester cannot block traffic, driveways, streets, or building entrances unless they have a permit. So, you think about a march, for example. There are usually permits, and that's why people are marching on city streets. Law enforcement is involved, city officials are involved. They grant those permits, and that allows people to be marching through the streets and traffic to be closed off. That without a permit, that is something that a protester can't do because they're obstructing other members of the public and their right to be in those same public spaces and public thoroughfares. Uh, Again, I've talked a lot about this being in public. A protester cannot trespass on private property or on restricted or secured areas because those are not open to the public. They're not a part of that free assembly. And not in that same government standpoint of publicly available property. Certainly, to the extent a protest happens, that can't include threatening or inciting others to imminent lawless action. It's something that certainly to the extent violence happens, that is unlawful. And the United States Supreme Court has created what we call the fighting words doctrine, that to the extent that there is an inciting of imminent lawless action, that goes outside the bounds of free speech and the rights of a protester. While individuals can document what law enforcement is doing, they do not have a right to intentionally obstruct police officers that are performing their duties. And we'll talk about the specific Colorado law on that in just a little bit. As part of protests, individuals should not carry and don't have a right to carry real or realistic looking weapons without complying with all applicable laws, whether that be state laws or local ordinances, concealed carry permits, those sorts of things. Similar when we're talking about local regulations and ordinances, there are times that depending on where you are located, the individual county or municipality, that amplified sound may not be allowed without specific permits. So what does that look like in terms of what law enforcement can and cannot do? Law enforcement certainly can order dispersal of a protest or a crowd if the gathering becomes unlawful. It must become unlawful before law enforcement is allowed to disperse or break up that gathering. What would make something unlawful is that it has become dangerous, it's become violent, or there is that inciting, of imminent threats or imminent breach of the peace. When and if law enforcement were to do that, they do have certain requirements in terms of how that has to be done now in the state of Colorado, in terms of giving specific notice of the fact that the gathering has become unlawful and that people do need to disperse. They need to give people ample time to disperse. They need to give multiple warnings, and they need to give the individuals in a space to actually be able to exit. There's this term called kettling, where law enforcement cannot surround the group and therefore make it difficult for the group to actually determine how they can exit from that demonstration or from that protest, and then being caught up and not being able to actually follow the dispersal order. Law enforcement or local officials can require a permit based on local regulations or for large gatherings that may substantially impact traffic, government facilities, access to buildings, those sorts of things. In doing so, however, they can only do so with reasonable time, place, or manner restrictions. So with that, for example, they can say that amplification limits can be put in place depending on where the demonstration is happening. If it's near a school, if it's near public buildings that are conducting business, they do have the ability as a manner restriction to put that sound amplification limit in place. Similarly, they have the ability to do permitting requirements, but those have to be applied across the board. As we'll talk about more in a second, that can't be based on the message, that can't be based on the group that's protesting, the individual that's protesting. It has to be entirely content neutral. Law enforcement can use reasonable force to manage or an unlawful assembly after issuing that clear dispersal order. And we'll talk about in in an upcoming slide some limitations that we've put in Colorado, specifically post George Floyd, as it relates to protesting requirements or law enforcement's ability to engage with protesting that have been put into place in Colorado law. And then, of course, in terms of detaining or arresting somebody, they can only detain somebody if there's reasonable suspicion that they've committed a crime, and could only arrest somebody if they have probable cause, a higher standard at that point, that a crime has been committed. That could be anything from blocking traffic to trespassing on private property. That could be damaging property, or certainly it could be engaging in any sort of violence. Police cannot arrest protesters for their message alone. Again, that needs to be content neutral or viewpoint neutral, because any sort of viewpoint discrimination by the government, by local municipalities, by law enforcement, etc., is clearly unconstitutional. Similarly, they can't deny a permit solely because of the message or the group or what the protest is about. There can't be blanket permit requirements for small spontaneous gatherings on public sidewalks. That is based on some federal guidance from courts saying that ultimately, if something happens and there is this sort of immediate reaction by a small group of individuals and they want to demonstrate, they want to protest, that can't be curtailed with some arbitrary permitting requirement. Certainly, force cannot be used indiscriminately against a peaceful crowd. That's would seem to make sense, but unfortunately, we've seen over and over that unfortunately that has happened. Colorado, similarly, post 2019, 2020, imposed laws in terms of what that needs to look like and how law enforcement can lawfully use force against a crowd. It certainly can never be against a peaceful crowd, and can only be done after the dispersal order, and can only be done in certain ways that we'll talk about here later in the presentation. Law enforcement, whether it's protesting or other circumstances, they cannot search you or your property without probable cause or without your consent, with a limited exception being if they're in contact with you and they have concern that you maybe have a weapon on you. There is a limited ability to do a pat-down search for weapons without the need for probable cause. But beyond that, to do any sort of real search of you or your property, that does require probable cause or your consent. And depending on where and how that search is taking place, may also require not just probable cause determination by the officer, but a judicial warrant that is determined that there is probable cause by a neutral judicial officer. And then, as I've talked about, you have the right to video something or photograph something. So because of that, law enforcement cannot deny you from videoing or photographing anything that is in plain view. They cannot delete your photos or recordings. They cannot take your phone without probable cause or your consent. And they cannot search your phone without your consent or your warrant. Notice the distinction there in terms of they may be able to take your phone with probable cause, but then to actually access the phone and get into the phone, that's where there needs to be a consent or a judicial determination with a warrant to actually go into that phone and search that phone. So I talked a little bit about some specific Colorado laws that come into play beyond just sort of those broad constitutional protections. The first I've alluded to a couple times, and that is from Senate Bill 20-217 in 2020. That was the what they call Enhancing Law Enforcement Integrity and Accountability law that was put into place. It's the law that required body-worn camera usage, but it also did some specific protections as it related to protesting. It limits the use of chemical agents such as tear gas and pepper spray and when that can be used. It also limits the use of projectiles against peaceful protesters. And that is where it laid out the clear guidance that officers have to give that clear warning that an assembly has or demonstration has now become unlawful and give that dispersal order. They then have to give an opportunity to disperse. We've seen nationally where demonstrations have happened and law enforcement almost simultaneously gives a dispersal order and then doesn't give an opportunity for a large crowd to actually then disperse before engaging in crowd control tactics, such as chemical agents or projectiles. So Colorado says that warning has to be put in place. There needs to be an opportunity before deploying any crowd control measures. And it also specifically says, and we saw some lawsuits against the city of Denver in the post-George Floyd protests, where projectiles, it was alleged, were aimed at particular areas of protesters' bodies. So the law now says projectiles cannot target the head, pelvis, or back of any individuals. Now, in real practice, to the extent projectiles are used, may they hit the back, pelvis, or head of somebody? Yes. But what the law says is law enforcement cannot target those particular areas of individuals. There's a couple laws that come into play when we think about protesters and what protesters should not be doing. First is inciting a riot. Protesting is, of course, and demonstrating is, of course, very different from a riot. But individuals can be charged if they urge others to commit violence. So if they go beyond protected speech and freedom of speech, freedom of assembly is always lawful. However, incitement to imminent violence or use of fighting words, or of course engaging in other crimes, unlawful activities, or engaging in destruction of property or violence is going to be unlawful, regardless of the fact that it started as a part of free speech, as a part of protesting, or as part of a demonstration. As I mentioned earlier, individuals that are protesting do not have a right to obstruct government operations. And so that's this distinction between observing what law enforcement is doing, documenting it, recording it, photographing, that is all lawful. But to the extent somebody intentionally impairs, obstructs, or hinders law enforcement by using or threatening force, physical interference, or violence, that is unlawful and is not a free speech right. So, of course, that verbal criticism of law enforcement is protected speech, but to the extent that gets to a physical interference and impairs physically their ability to do their job, that does become unlawful. Always keep in mind that local ordinances may vary, and that's specifically when we talk about those areas of permitting and sound amplification, what may constitute a large demonstration or a large organized protest. Those are things that are controlled in many cases by local ordinances. For example, as I understand it, Denver requires a permit for events on city property that involve 25 or more participants. However, and as I noted before, spontaneous protests in response to breaking news events are generally going to be exempted from advanced permitting requirements. And then, of course, we do have open records laws in Colorado. We call it CORA, the Colorado Open Records Act, which allows citizens to request police body-worn camera footage, incident reports, and other documents related to protest incidents. And part of that, as specifically as related to body-worn camera footage, was expanded in that Senate Bill 20-217 as well, with the advent of the requirement for body-worn camera across the state. So to the extent that you or somebody that you know is detained or arrested as part of a protest, there's certain things to keep in mind. Number one, stay calm, never resist. ask if you are free to leave. If you're engaged with law enforcement, you have the ability to ask if you're free to leave. If they say yes, then calmly remove yourself from the situation, calmly leave that encounter with law enforcement. If you are told you are not free to leave, do not physically resist, even if it may be that the arrest is later determined to be unlawful. An individual cannot physically resist. Resisting arrest can result in additional charges and escalate danger. The resisting arrest could still be a valid criminal charge, even if the original law enforcement contact was unlawful. That original detention or arrest, if that's unlawful, that is to be dealt with through proper legal channels. But if somebody engages in physical force or physical resistance with law enforcement, they could be charged with obstructing government operations or resisting arrest. And those would be charges that would still be valid charges. An individual always has the right to clearly invoke their right to remain silent and to clearly not consent to a search. So you always have that right not to answer questions beyond providing identification, as I talked about before. So to the extent you don't want to speak with law enforcement, you provide your identifying information. And then at that point, if you choose, you can say, I am invoking my right to remain silent. And then you are never required to consent to a search. Law enforcement then has to determine if they have probable cause to engage in a search or if they have probable cause to ask a judge to issue a search warrant. If law enforcement, again, violates those Fourth Amendment privileges, it is still helpful to be very clear that you state, I am not consenting to any kind of search. That would be documented on body-worn cam for the law enforcement. It could also, and likely in a protesting situation, will be documented by other protesters that may be filming that interaction. But ultimately, again, not physically obstructing law enforcement or physically resisting law enforcement for fear of other charges that would then still become lawful charges against a protester if they engage physically with law enforcement. And then, of course, you have the right to request an attorney. You have a right to an attorney during custodial questioning and during legal proceedings. That doesn't mean somebody always has a right to a lawyer at any time that they're talking or dealing with law enforcement. But to the extent you are in custody with law enforcement and law enforcement wants to ask you questions while you are in custody, you have a right to a lawyer. You also, of course, have the right to not engage in that questioning and not answer that questioning. And then if charges are filed, somebody always has a right to legal counsel during a criminal justice or court proceeding. And then finally, document and report anything. Obtain recordings that may exist. I noted in a protesting situation or a demonstration situation, there's likely going to be individuals that may have cell phone video. Try and obtain that information. Document the names of individuals involved, whether that's law enforcement individuals, witnesses, other people that were at the demonstration, etc. And then to the extent that there is any violation of your rights under the constitutions or under Colorado state law, reporting that through proper channels to the law enforcement agency, if law enforcement is involved, to local government, to the Attorney General's office, to the Civil Rights Division, et cetera. A number of different channels that you could report that through to the extent that there is a deprivation of your rights. So some practical tips to think about when we think about engaging in a demonstration or protest. Bring identification. Have emergency contact information readily available. In today's day and age of cell phones, there are a lot of numbers I probably should know that I would have known 20, 30 years ago because I would have needed to keep them in my head. Now I click a few buttons on my cell phone and I know that I don't need to memorize many numbers. but you should have that emergency contact information available in case you don't have your phone, in case you have to make a call to somebody, in case you need to get in touch with somebody. Um, Always stay peaceful. Always stay calm, stay peaceful. Think about the reason that you may be engaged in the protest and what that bigger message is that you're trying to say, and doing that peacefully. Always document things safely. That's where I've repeatedly said you never want to physically engage with law enforcement, but you're absolutely welcome and should document things that are taking place, but doing that in a safe manner, in a non-obstructive manner, and a non-physical resistance manner. Having a plan for meetup and exit. A lot of times when we go to a protest, we're doing that with other individuals. Think about where you're going to meet up with those individuals. Think about where you're going to be during that protest, and think about what your exit strategy is if things go south during that protest. Think about where you're going to meet up when the protest ends, or if the protest is dispersed, so that you're not separated from the individuals that you should be with. Um, and then knowing what to do, which all of you are doing great work being a part of this activism training today and the activism series generally through the League of Women Voters of Colorado. But know what to do if you're confronted by some individual, if you're questioned by law enforcement, if you're detained by law enforcement. Thinking through not only what your rights are, but what you would do, how you would handle that situation. I'll give you a quick personal example. I live in the city of Erie here in Boulder County, and I was at a rally, the last No Kings rally, and I had thought through, how is this going to go? How am I going to react? I took my daughters with me, who are 11 and 14, and I talked through that with them. And I thought I had a great plan. Things were going fine. There was some really unfortunate things that happened, but we handled that well. And by unfortunate, they weren't terrible. There was individuals who were purposefully driving their truck and revving their truck to blow black smoke on the exhaust smoke on the protesters and the rally goers. There was some woman who decided to moon everybody going up and down the street as her husband was driving and she was in the passenger seat. Number of individuals that had flipped us off. I'm sure you all, if you've been at protests, you've experienced that. I knew what to do with that. I had planned for all of those things. My daughters knew what to do, and essentially it was not to react. However, there was one thing I didn't plan for. There was an instigator there, a counter protester. That was his right. We had planned for that. We talked about it. We knew we weren't going to react. I talked to my daughters when we first saw them. I told them, don't react, pay no attention, turn the other way. We did that great. Unfortunately, this individual, as he came back around the second time and was engaging with a number of people and people were yelling at him, we kept our business to ourselves and tried to stay out of it. But then somehow he saw my 11-year-old and 14-year-old standing near me as he was yelling and back and forth with other protesters, and then referenced my daughters and started yelling at my daughters. That I was not prepared for. And frankly, I didn't handle it the best. I was willing to have somebody confront me. I was willing to deal with just sort of the general things. I was not willing to have somebody yell at my daughters or confront my daughters. And I engaged with the individual, not physically, but told him he is not welcome to speak to my daughters and he needed to go the other way and needed to stay away from my daughters. He then engaged me physically. And, it escalated from there. Ultimately, everything was fine. I was fine. But those are the things that, and I give that example because those are the things that may happen. Those are the things that we need to be prepared for, that we need to have a plan for, to making sure that things don't escalate and to make sure that we are both protecting our rights and protecting our own safety when we're engaged in this. Because, like I said, just as we have the rights to protest, other individuals have the rights to counter-protest. Certainly the individual that I was dealing with, he had the right to counter-protest. He did not have the right to physically hit me, and that was dealt with. but ultimately, um, those are things that we have to think about in terms of how will we stay peaceful, how will we engage in that, while at the same time doing our civic engagement, making our voices heard. It was important for me to be there and to make my voice heard. And my daughters chose to be there, and I thought it was great. But having that plan, thinking about my rights, thinking about their rights, and thinking about how I keep myself and others around me safe. So I did almost exactly what I wanted to do. Wanted to leave about 15 minutes for questions. So again, the idea here was to really do a high level overview of rights, of keeping ourselves safe, of what we can and cannot do. Um, but I'm excited to answer any questions that you may have, and if I can be a resource on anything like that.
Excellent. This has just been great. Thank you so much, Christian. I know I have learned a few things, and from the chat, a few other people have as well. I know Jeff, I do see your hand. Uh, Kathy is asked, well, let's see, hold on. Uh, got that one. Does SB 2217 apply to federal officers in Colorado or only to state and local officers?
That is a great question. Unfortunately, it only applies to certified Colorado law enforcement officers. Um, the struggle with states is what our ability is to control the actions of federal law enforcement officers. And since 217 is largely about more administrative regulations, those are things that we don't have the ability as a state legislature to control for federal law enforcement. That said, state law, to the extent they violate a state legal provision, that is something that the state can and should take action for. So, for example, if federal law enforcement were to assault somebody, God forbid, kill somebody in Colorado, that is separately a violation of state law, and state action can occur as it relates to that. But we can't necessarily regulate, say, body worn camera usage or issues as it relates to how they would give dispersal orders or how they would respond to um, protesters, those sorts of things.
So if ICE came in, would they have more authority? Would they have authority over local police?
So, in terms of over local police, do you mean they certainly would have authority to the extent they're engaging in their lawful duties? Um, that doesn't mean that they would come in as a separate agency to deal or enforce with state law. But to the extent, let's say they're engaging in immigration enforcement, whether we agree with that or not, or want them to be here or not, that is part of their legal authority as law enforcement, if we're thinking about ICE or border protection. Um, and they have the ability to engage in that. And to the extent that something happens to them. So we think about, I'll give you the example that is on my mind, and I imagine many people's minds. What happened in Minnesota was absolutely horrendous and terrible. Those law enforcement, federal ICE and law enforcement officers were lawfully in Minnesota. They were lawfully engaging in their duties of immigration enforcement. Um, to the extent that individuals then physically engage with them, they do have the ability to then enforce that or react to that, if you will. But they shouldn't otherwise be engaging in any generalized law enforcement activity in our state. They don't have authority to do so, and they have no more rights to do so than local law enforcement. In fact, they have less rights to do so than local law enforcement.
Okay, thank you. That's helpful. Jeff?
Christian, thanks for your presentation. Appreciate having you here. And I'm sorry you had that experience with your daughters. That's unfortunate, but you're in the spirit of making change, so to be expected, I guess. My question maybe is just a little bit peripheral to protesting, but we see so many videos, and I guess this is in the spirit of me trying to save my car windows. Um, Mister, get out of the car. When I hear that, where do my rights begin and end?
That is a great question. So obviously, it's going to be very fact and situation specific in terms of what is going on. At that point, has law enforcement, be it local, state, or federal law enforcement, determined that they have reasonable suspicion or probable cause to get you out of the car? Um, if they do, then at that point, that's a lawful request. What it will tell you and what the slides indicated is, frankly, even if it is not a lawful request, I would argue that there were non-lawful requests that were done in Minnesota. Um, but when we think about the interaction between rights and safety, I'm always going to go towards safety and say that yes, that may not be right that they say stop or that they say get out of your car, and they may not have a legal justification. But to the extent that you don't, we don't want you to be unsafe. We don't want something to happen. And so you are better off complying with that order, even if you're questioning its lawfulness, and then dealing with it through proper channels after the fact.
Great. Thank you.
Great segue to the next question. What is the best action of recourse if rights are being ignored?
Great question. I think it largely depends on, and I'm a lawyer, so I always say it depends, and I apologize. But I'm thinking through all the circumstances. It depends on what's going on, what the rights are, and probably most importantly, who is violating those rights. So to the extent we're talking about ICE agents violating your rights, unfortunately, I don't think I could give you a great answer in terms of what to do or anything good coming of any complaint, even if you did make a complaint. Um, but if we're talking about state law enforcement, local or state law enforcement here in Colorado, there are a number of avenues that you could take. That includes reporting it through the local law enforcement agency that employs that law enforcement officer. That's where I always tell people to start. That can also include reporting to your local DA's office. It could include reporting to the Attorney General's office. I will tell you that the Attorney General's office now has a hotline specifically for reporting, specifically ICE concerns about actions by ICE so that they can take a look. But I think the same would still apply in terms of if you don't get appropriate response from the law enforcement agency or from your local DA, I wouldn't hesitate to contact the Attorney General's office. You could also contact the Police Officer Standards and Training Board, who certifies police officers in the state of Colorado. So those are the first things that come to mind, that there's a number of organizations that you could report that violation of rights to.
Great. Suzanne, I'm not sure if you feel that your question's been answered. Would you like to come off mute and let us know?
Yeah, I just unmuted. So
Right.
I think Kristen, you did mention that you thought ICE agents would be subject to state criminal prosecutions. Did I hear that correctly? That would be kind of my first question to clarify.
So yes, I will tell you, I actually did some deep dive rabbit hole research as it related to that after what happened in Minnesota, and engaged with my boss, Michael Doherty, about this because we were very concerned about what may happen in Colorado. ICE does not have just blanket immunity, and they can be held accountable for state law violations. There are a couple caveats to that, though, I've realized. One, which, to be honest, I had no idea, even doing this for 18 years, is as a federal agent, they would have the ability to remove that to federal court. We would still prosecute it, but it would be handled, let's say, God forbid, something happens in Boulder County. It would be the Boulder County DA's office prosecuting that potentially in Colorado Federal District Court, if the federal agent seeks to remove it to federal court, which they would have the ability. As it relates specifically to their immunity, it is certainly not absolute immunity. I'm just looking at your question. And as it applies to criminal prosecutions, essentially that federal court, if they removed it to the federal court, would determine whether or not somebody was acting reasonably within their duties and under their guidance as it relates to, federal policies, federal laws, and doing something that was a part of their job duties. So when we think about that, thinking about Minnesota, for example, I imagine if a criminal prosecution were brought, of course, they would say, I have immunity because I was engaging in my activities as a federal agent. On the flip side, though, the prosecutors, be them federal or state prosecutors, probably not federal, we know, with the way things are right now, would say, yes, you were acting as a federal agent, but you certainly were not doing so reasonably and not within the bounds of your requirements. And then it would ultimately be up to a judge to decide. So definitely not absolute immunity, and frankly, not the same as qualified immunity. Qualified immunity is more of a civil mechanism for civil rights violations. But I suppose if we think about it within that area, it does fit more within that idea of qualified immunity, but a little different from the typical term that we would hear in the news or anything like that as it relates to qualified immunity, because that is not a criminal law principle as it relates to qualified immunity. But there is federal case law that says it's not so much immunity as much as it is not being subject to prosecution if they are doing things essentially lawfully. The question, of course, becomes how far does that extend, right? I think we can all agree, current environment aside, it's difficult in the current environment, I imagine, for many of us. But current environment aside, we don't want to see law enforcement get prosecuted or held liable civilly if they're doing everything right, whether that be state law enforcement or federal law enforcement. And that's the idea behind qualified immunity, and essentially the idea behind this criminal mechanism that the federal courts have put into place around operating as a federal agent and doing so in the course of their duties and doing so reasonably and within the bounds of their duties. The issues, of course, become when they are not operating within their duties and when they are violating clearly set constitutional provisions and violating clearly set rights of individuals.
Okay, thanks very much.
Of course.
Okay, we're at time. Does anyone have any last very short questions for Christian? Is there any real threat of Rubio declaring protesters terrorists and revoking our passports?
Frankly, I would have said a lot of things were not a real threat that have happened in the last year, if I'm just being very candid with everybody on this call. So I would never say never. That said, I think even under the current climate that we have with the federal courts, that would be really hard, even if Rubio were to do that, for that to be upheld in any meaningful way in federal court. So I would argue it's not a real threat of it being enforced. Do I understand the concern and that there may be a threat that somebody in this administration would try to do that? Yeah, maybe there's some level of threat that they could try to do that. I don't feel like there's a real threat that the federal courts would uphold that. That would be um, just so blatantly unconstitutional, absent, again, any sort of criminal activity that the protester engages with. So, to the extent you're engaging with free speech and protected speech, I don't think it's a real threat. But if that then veers off into a physical confrontation, into inciting violence, that's where it becomes more of a problem.
Okay. Christian, this has just been fantastic. It really has. May I ask if you're willing to share your slides?
I definitely will. As soon as
Great.
we're off the call, I will forward those your way. And so you're welcome to share those out.
Excellent. Thank you kindly. To all attendees, we will forward slides and a video recording of this meeting to you. Thank you for being here. Thank you, Christian, for being here. This is, again, really just been fantastic. If you found this presentation worthwhile and would like to support the League of Women Voters in our work, please feel free to do so. There's a QR code that will take you directly to a way to donate. But we appreciate all of you for your interest and motivation and commitment to American democracy. Thank you so much and have a lovely evening.
Thanks, Beth. Thanks for having me. And thank you all for being here.
Thank you, Christian.